All right, everyone, we are just about ready to get started. The first thing I want to do is point out to you, particularly if you're not used to
This
doing
conference is being recorded. Only the main conference is recorded.
I would ask you to turn your microphone off until we are ready to talk to you, because we hear all kinds of things that we don't need to be hearing if you have your microphone. We are going to start with our civil docket. We have two cases on. The first one in order of chronology is 19 CI 136, Everett Cash Mutual Insurance Company. It's a subrogation case versus Fancher.
Janet Liu on behalf of Everett Cash Mutual. That's our motion for a pretrial conference.
Yes, ma'am.
I'm representing Mr. Fancher.
Yes, sir. What are we, let's see, what's our objective here? Do you want just some deadlines, or?
We eventually like just a trial date, and realistically, I think there's a good chance that we will well, I don't know if Mr. Ross is going to object to it, but we will likely be okay with a bench trial. I can't agree to that just yet, but that's what I'm thinking.
Judge, I would prefer a jury trial at this juncture. I need to clear that with my client.
Well, as you all probably know, the trial situation is pretty complicated, and of course, not that your all's claims and defenses are not important, but on the order of importance with people who are in custody and cases that have child sex abuse victims, and that prioritized all the way down the road. An argument between two insurance companies about money, or two folks about money, is going to be way down on the list in terms of priority. That being said, I can go ahead and schedule a trial. I can already tell you, because I had this conversation yesterday, scheduling a trial in the car wreck case, and the first available trial date I had to try to get beyond these criminal cases was May of next year. So, anything I give you all is going to be May or later of next year if it's a jury trial. Now, you can probably squeeze a bench trial, or, this probably ought to, I don't know for sure, but it probably ought to be mediated, because that's how these things, in my experience, are getting resolved for the most part. But that it's premature for me to say that, I guess, because it hadn't come up. But that would be my inclination, is that would be the most likely and the quickest way to get this thing resolved. So all that being said, if you want me to go ahead and set a trial date, I can do that. Like I said, it'll be, I can't even remember where I filled up the first 2 weeks of May. I know I set 3 cases. So we'd be talking about somewhere towards the end of May.
That'd be fine with us, Your Honor. I don't have anything scheduled yet for May of 2022.
Yeah, I would, I wish I didn't, but there we are.
Yeah.
All right. So, what are we thinking here? Could this be a one-day deal?
I think so.
I agree, Judge. One day.
Yeah. Mr. Ross is a man of few words. I'm surprised I have gotten this much out of him. So I think he could handle. I think he could handle it in a day.
Yeah, I agree, Judge.
Yeah. Well, would you like to? I could do that middle week of May, that third week of May. Is pretty much open. So Tuesday the 17th, Wednesday the 18th, Thursday the 19th, or Friday the 20th. Any one of those days would be. Friday might not be the best for you guys, but other than that, any of those days is fine. I would, let me say, probably the Tuesday would be the best, just from the standpoint of everything else that goes on in Metcalfe County. If I do Wednesday, I'll be interfering with their district court docket. And if I do Thursday, I'll be interfering with their family court docket. So Tuesday, I think we'd have the building to ourselves if you all could live with Tuesday, the 17th.
That works for me.
That'd be fine, Judge.
All right. Why don't I, typically I do address in the order setting a trial, I do address mediation. I do not always order it, but I either say that the parties, can mediate it, or I say that they shall mediate it. I don't know if anybody feels extra strongly about that in this situation, but to me, I think this is probably something that you all ought to give that a shot. And it may not be ready to do right now, but I mean, since we've got that much time, I think it.
We have no objection to any mediation order date setting. That'd be fine with us, Your Honor.
Okay. And probably what I would do is just direct that it gets done prior to the pretrial conference, which I'm going to set in just a minute. But we can set that pretty far down the road if it'll help you all. Just like I said, there's no rush. So can you all live if I do a pretrial conference, say in maybe in November or December?
That'd be fine, Your Honor.
Let me look and see what I have available. We would have, say, hypothetically, November the 9th might be a good day.
That'd be fine with us, Your Honor.
Tuesday,
fine.
November the 9th. Okay. So
What time?
that'll be 9 o'clock. It'll be on a docket like this. Usually I have a pretrial compliance in there just for everybody to be sure they've completed all their discovery and whatever the case may be. And I doubt this is an expert witness kind of case, but if there were any experts, that would all have to be taken care of before the pretrial and the mediation taken care of. So I'll have that in the order, and then if there are any questions, you all can get back with me.
Thank you,
All
Judge.
right, thank you so much, Your Honor.
Thank you. All right, Crystal, that one. My next case will be Transportation Cabinet versus Neal.
Your Honor, this is Ann Meyer and Alex Blackwell for the Transportation Cabinet on our motion to hold Mr. Coy Neal in contempt and order for sanctions.
Okay. Do I have Mr. Neal on here?
Your Honor, Mr. Neal called our office yesterday and we spoke with him. He indicated that he was moving vehicles and were we going to have a hearing? And we told him, yes, we were still going to have the hearing because we had received information from the local district office in Bowling Green that he was still parking on the right of way and had not removed sufficient vehicles from his property to comply with your default judgment entered on February 23rd of this year. He indicated to us that he was going to contact the clerk's office to try to attend the hearing, either to find out if he could do it in person or through other methods.
Right. I was informed by the clerk's office that he planned on joining the Zoom hearing, but I don't see him, and I don't know if, I guess conceivably he might have had difficulty doing that. I was going to make this suggestion, and that was going to be that I have a little bit of trepidation about doing anything irrevocable when we haven't been able to see anybody in person. Obviously, you have your judgment, and at least on the face of your motion, there have been some problems with complying with that judgment. What I was going to propose is that
he gets off scot-free.
I issue an order either, if you prepared it, it'll get issued a lot quicker, but because I'll be in court all day, but I mean, I could issue it, I could do it, work on it in the next few days, but issue an order that just directs him to appear in person the next time we're going to meet, because we're going to be able to have some in-person proceedings once May starts, if I feel like they're necessary. And in this case, I think it probably is, because we've had 2 hearings and he hadn't gotten on either one of these Zooms. So maybe say on May the 11th, which is our next time that we're going to meet, I would be fine just because you all are pretty far off. If you wanted to appear remotely, that would be fine with me, but he could appear in person and we could, figure out a way for everybody to talk to each other. And I just feel like maybe that would be a better idea. But I mean, in the meantime, I would expect him, especially if he told you that he was going to be rectifying this situation, I would expect that to continue. And I don't know if he's going to contact you or what, but if he did, you would be justified in telling him that this is not a reprieve of compliance with the court order. I mean, this is just basically going to build in 2 extra weeks for him to comply with the court order and try not to be in trouble next time we talk.
Okay.
Does that make any sense?
Yes, I have, no, I understand perfectly, Your Honor, and we can prepare the order.
Yes, Your Honor.
Yeah, all it really needs to, I want it to be clear that he, that his compliance, like I mentioned, is not relieved. He's still expected to comply with the previous judgment of the court. And if he has not, I think it'd probably be better not even to put that wiggle room in there. Just say that he shall appear on the 11th at 9 o'clock to address the allegations in your motion.
Okay.
I don't want there to be any question about him saying, well, I didn't show up because I thought I had complied or whatever. I think we just need to have him comply. And then if he shows up and everything's hunky dory, we can tell him that and move on.
Okay, so basically just an order continuing today's hearing until May 11th.
Yes, sir. I just want to make it clear, and however you want to do that, but I want to make it clear that we're not hitting the pause button. I mean, I expect that this is just giving him some extra time to clear it up, if that's his intent.
Your Honor, we can
And
get
I hope it is.
that. And then how would you like us to just e-file that, or do you want us to email it?
If you e-file it, I'll get it quicker and I'll be able to sign it quicker.
Okay.
Okay.
Thank you.
You just upload that thing and next time I log in and it's in there, I'll sign it.
Okay. That sounds,
Okay.
Thank you, Your Honor.
All right, you are welcome. And like I said, if you all want to come in person, that's A-okay. But because we will be having some, limited in-person things when May the 11th rolls around, and we'll also be doing a Zoom docket too. So if you, I'll have the Zoom up, and if you all join that way, I'll know you're there. Okay.
Thank you, Your Honor.
All right. Thank you. All right. That gets us to our civil docket. Let me remind you all, please, whatever device you have on, hit the mute button on that thing until I'm ready to hear from you, if you don't care. I know that we have Adair County Jail on here. I think maybe we just have 1 or 2 folks in Adair County. So why don't we try to take those? Well, yeah, hold up. Let me back off of that for one thing. Miss Atkins has a previous engagement, and if she's going to be testifying, I need to let her do it so she can leave. I told her I'd get her as close to 9 o'clock as I could. But I don't know if you all need her.
Julie, have you got a subpoena in the Vincent matter? Is that
Trevor Burton.
Trevor? Okay.
Do what? Oh, God.
Hey, seriously? All right, Mr. Gardner, you have the floor for the moment.
Mr. Burton's case is actually Mike's, I believe.
It is,
Okay.
Judge, I'm on that case also. Mike had sent me an offer yesterday afternoon after court that I didn't read till this morning when I got back from the jail. And I met with Trevor up there this morning, and I believe we've got an offer that he's going to want to take so that we can resolve both Barron and Metcalf cases and the pending motion to revoke his bond. If we could do, I was wondering if we could put his case on for next Monday in Barron County. And perhaps we'll have the agreement finalized by then in both cases.
I can do that if you want me to. Will that allow us to let Miss Atkins go so she's not waiting? I mean, we can talk about whatever else we need to talk about,
Okay.
but Yeah.
I hate to speak for Mr. Richardson because he's the one, I guess, that subpoenaed her, but I don't need her for anything. So that's all I can say about that.
Gotcha.
I wouldn't think he would need her, but as sure as I say that, he'll want to put something on the record with her.
Mike, what do you think?
I'm sorry, Judge. I was on the phone with Johnny had called me. He was asking me about Bradley Wilson, so I didn't catch what you had said.
All right.
Sorry.
Yeah. Julie was needing to get out of here, and so I think all she's been subpoenaed for is the Trevor Burton. Greg says that he's pretty sure you all have an agreement in that case, but he didn't have your full offer when he talked to Mr. Burton, but he says that he believes that that's going to be something that he agrees to, and he wonders if we could just put it on for Monday and do, because he's got a Marion County case also, and just do them both on Monday.
Yeah, we got a deal, Judge. That's fine.
All right, so I can let Miss Atkins go and she can take care of her business. Thank you, Miss Atkins. And then Mr. Barry will do that. That's fine.
Okay, Jeff.
You want to do it in the morning or the afternoon?
Either one's fine. I guess the morning.
I will put Mr. Burton's case over to 5-3 at the 10 a.m. docket.
Okay, Jeff.
And we'll have the Barron County case brought up too. If you remember yesterday when we arraigned him, we set it out into June for a pretrial, but we all kind of knew that we might be moving it back up. So,
okay.
All right. Thank you. Let me call, looks like I got Mr. Rowe sitting there ready to go in Adair County. And I only have 2 inmates in Adair County. You know, they don't want to stick around all morning. So let me, they're accommodating us. Let me go ahead and take him and then Miss Hoffman will do them sequentially and get them out of the way. Thank you. This case is set right now, at least, for a probation revocation.
It is, Your Honor. We've reached an agreement, I believe, in this case. I've sent Mr. Austin an email this morning saying I would agree in lieu of revocation to a sanction for time served on this matter. He indicated that he thought his client would agree to that. I don't think he's had an opportunity to speak to him yet about it.
I haven't, but I don't see any reason why he wouldn't accept it.
560, buddy.
Will you accept it, Mr. Rowe?
Yes. Yes, I can.
Yeah, I think that's probably a
Can you hear me?
That's probably a pain-free resolution from your standpoint.
That's how I feel.
Yeah.
Yes, sir.
Yeah. All right. So, Mr. Rowe, the upshot of this is that when you get out, you need to be reporting to your probation officer. And I don't know if Officer Ford is on. Yeah, there she is. What do we want to tell him here on the record, Officer Ford?
You cut out on me and froze up.
Oh, listen, what's going to happen here, Mr. Rowe, is that your probation officer is going to tell you what she expects you to do when you get out.
You're still freezing up on me. I don't know what it is.
Can you hear me?
Yes.
Okay, so when you get out of jail, it's your obligation to call me daily.
Okay.
Because you often don't do as you're
I heard
told.
the obligation to call daily, but that was it.
Yeah, call me daily.
Okay, I understand.
Okay, thank you.
Thank you.
Are you going to be getting out today?
I'm not sure. No, I should probably not today.
Yeah, you got some other counties that.
Yeah, I have to talk to Adair County first.
All right. All right. So I don't know when you're getting out, but the day you get out, you need to call. Okay.
Okay. Yes, Your Honor.
All right. All right. That's all we
Thank
got.
you.
Thank you.
Thank you.
All right. Can we do Miss Hoffman next?
Judge, I've got 2 witnesses. I think we'll have to see if they're here.
Yes, sir.
Deputy Watson from the Cumberland County Sheriff's Office. I sent him the link, but I think he was having trouble getting in. And then there was Officer Burton from Adair County. I don't know if he's on here.
Yeah, he's on here.
Okay. Deputy Watson, are you on here yet?
I am here.
Okay. All right, looks like I got my witnesses, Judge. I'm ready to have a hearing.
Who do you want to call first?
We can call Deputy Watson first.
Okay. Wait, I lost him. There we go. Deputy, will you raise your right hand for me, please? Do you swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. Go ahead, Ms. Richard.
Can you state your name for the record?
Lance Watson,
And who do you work for?
the Cumberland County Sheriff's Office.
Okay, on April the 1st of 2021, did you arrest Jamie Hoffman?
I did.
Okay, can you tell the court what the arrest was about?
We was executing a search warrant on a residence, and we was clearing the home, and Miss Hoffman was hidden under a bed in the residence, and we got her from underneath the bed. And underneath her person was some what tested on a field test kit, methamphetamine, and inside of her pocket was some marijuana. She was placed under arrest at the time because she had warrants on her. And she was in a home with a lot of stolen items that we recovered, and she was aware that they were stolen.
Okay. We pass the witness, Judge.
All right, Mr. Austin?
That's Greg's.
Oh, okay.
Yeah,
Mr. Berry?
it's mine, Judge. Officer, what was she charged with? Receiving stolen property?
Are you talking to me?
Yes.
Yes.
We're charged with receiving stolen property, possession of methamphetamine, possession of drug paraphernalia, and possession of marijuana. I think that's all I charged her with.
Okay.
And she had 4 active bench warrants at that time.
Whose house was this?
Anthony Gilbert,
Okay, was Mr. Gilbert there?
he was not there at this time.
Okay, was anybody else there besides Ms. Hoffman?
No.
And do you know if anyone else lived there?
Just Anthony Gilbert.
Okay. Has Mr. Gilbert been charged with anything?
He is going to be indicted, but he is currently in jail at the moment.
Okay. I'm talking about arising out of this incident. Was he going to be charged with any of these as a co-defendant?
He'll be charged with receiving stolen property, and state police was actually assisting me with the warrant, search warrant, and they're going to take a drug case out of it for trafficking methamphetamine and opiates.
Okay. All right, I'll pass the witness, Judge.
Anything further of this witness, Mr. Richards?
That's all the questions I had.
All right, may he be excused?
Yes, sir.
All right, sir, thank you. You're free to go.
Thank you, Judge.
Who do you call next?
Officer Burton.
Will you raise your right hand for me, please? Do you swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth? So help you God. Oh, you're on mute still. Sorry. There we go.
Yes, sir.
All right, good enough. Ms. Richardson.
All right, can you state your name for the record?
Evan Burton,
And who do you work for?
Columbia Police Department.
And did you arrest a Jamie Hoffman on April the 2nd of 2021?
Yes, sir.
Okay, can you tell the court what the arrest was about?
Yes, I will make note that she was already in custody at the Adair County Regional Jail.
Okay.
I am going to refer a little bit to my case report. The Adair County Regional Jail contacted the Columbia Police Department in reference to Jamie Lee Hoffman promoting contraband. I did log this incident to the Adair County 911 Dispatch Center. I was assisted at the Adair County Regional Jail booking area by Police Sergeant Charles Greer. The Adair County Regional Jail female deputy jailers Leanne Roy and Brooke Wade advised they both located contraband inside Jamie Lee Hoffman personal property. That was her handbag. The Dare County Regional Jail female deputy jailers Leanne Roy and Brooke Wade stated Jamie Lee Hoffman was a current female inmate transported from Cumberland County, Kentucky, already being in custody. Can you hear me, sir?
Yes.
Okay.
Yes, sir.
I thought I was froze. I'm sorry.
No, it's all right.
I collected the evidence inside the booking area of the Dare County Regional Jail. And when I was walking into the jail, the female deputy jailers, Leanne Roy and Brooke Wade, they were collecting evidence out of that handbag in that booking area. I did send the evidence to the Kentucky State Police Forensic Laboratories for positive testing. We do have pending results. And I do have the citation number. It was Paul 315187.
Okay. We pass the witness, Judge.
Mr. Berry.
I wouldn't have any questions for him, Judge.
All right. So ultimately, there was a charge, are you telling me, of promoting contraband first degree?
Yes, sir.
Okay.
It's my citation here.
All right. Looks like you have promoting contraband, possession of a controlled substance, and then marijuana and drug paraphernalia.
Yes, sir. Yes, sir.
All
I
right.
do.
All right. Yeah, I had your citation. I just couldn't see. I didn't see it right off the bat, but now I saw it. All right. Are there any other questions of this witness?
No, sir.
All right. May he be excused?
Yes, sir.
All right. If you have not been subpoenaed for any other cases, then you are free to go. Okay. Thank you.
Thank you, sir.
Mr. Berry, do you have, or Mike, is that, Mr. Richardson, is that all the proof?
Yes, sir, it is.
Mr. Berry, do you have any proof?
No, Judge, I wouldn't want to put Ms. Hoffman on the witness stand at this point with these charges all pending.
You want to make an argument?
Yes.
Go ahead.
It's simply that she's not been convicted of anything yet, and I realize she doesn't have to be. It can just be charged, can result in a revocation in these situations. But I would ask the court to consider not revoking her at this point, to let these cases wind their way through the system and see if indeed she ends up being guilty of any of it. I think it's interesting, the case over in Cumberland County about other people being involved and what their involvement in the whole thing may have been, whether or not they're the main perpetrators or the only perpetrator. So I would ask the court to consider not revoking her at this point.
Mr. Richardson?
Judge, just to put it in perspective, I mean, this case first started off, a while ago as a pretrial diversion to give her a chance to not have a felony drug charge in her record. She failed to complete that diversion, and you ended up probating her since she had presumptive probation when you revoked her pretrial diversion. So she got another chance. So now here we are months later, and Officer Bray had filed the original motion. Officer Bray had filed a report with a new charge out of Barron, which she currently has that pending charge, and now that she's been indicted on. And now months later, she now has, and even besides the receiving, even if you take the receiving stolen property out of it, you still have you have a whole situation here where she's still dabbling with drugs. I think the sentence in this case was 2 years. I think we've tried everything we could to try to give her a chance to not have it on her record, and now she's got these new felony charges. And at the very least, if they don't get her on the receiving, I mean, they got her dead to rights on the drug charges. Anyway, I think there's more than enough at this point. She's had enough chances to where we feel like her probation should be revoked at this point.
Well, I can, because I'm the one that issued the warrant, I can take notice of the fact that I issued a warrant in June of 2020 for not reporting to probation and parole, and that warrant wasn't executed till April 1st. It was served on her when this other arrest in Cumberland County was made. So, that's absconding and failure to report. The reason that that even came back to our attention was because after the pretrial diversion was voided, I ordered her to get an assessment and comply with the treatment recommendations, and that didn't happen either. And so, I mean, at the end of the day, I think the conclusion is inescapable that pretrial diversion did not work and probation did not work because there's been no attempt to cooperate with the supervision. Based upon the absconding and the 2 new felony charges in 2 different counties, I think the Commonwealth has carried its burden of proving that that Ms. Hoffman is not submitting herself to the supervision of probation and parole, and her failure to be compliant is dangerous to the community. It's resulted in 2 new felony charges in 2 different counties. So I'm granting the motion to revoke probation, and I will enter an order accordingly. Okay? All right. Ms. Hoffman, good luck. Thank you.
Thank you, Judge.
Thank you. Be careful. Let's see. I think we've got the Barron County Detention Center on here, so let's get them in and out. If you all can, if we can. I had a list of everybody that was in jail, but I can't find it. Here it is.
Judge Alexander,
Yes.
I just have that one, which is John Martin. There's a motion to revoke, but he's currently, y'all may have received something. He's currently at Life Skills.
I think we just need to set a hearing date on that, Judge.
Yeah. Let's just set that for let's see. It looks like his treatment letter says that he is expected to get out on May the 14th. I guess what I would like to do is maybe put this on for May the 11th to see if he's still in treatment, and if he is, then we can schedule the hearing for when he gets out. But I mean, if he leaves before the date that he's supposed to leave, then I want to be able to go ahead and address it. Okay.
Judge, I know there is, I talked to his father, there's an issue potentially with insurance that's gonna cover him for a couple of weeks. I'm not sure it's gonna get him to the end. So I told him they need to be checking on that and possibly speak with Julie maybe and see what she can do to help try to keep him in there.
Well, that's fine. I just want to be able to take a look at it if he's not going to be in there for that duration. If he gets booted out because of insurance, then that's not going to be something that I'm going to, be too awful angry at him about. But
I just wanted to let.
Yeah, I understand. Ron, if he's still in there, let's get confirmation of that. If not, let's see him on May the 11th at 9 o'clock.
Okay.
Okay.
Okay. Thank you. That's
Thank
all
you.
I had. I just
All right.
Get a date.
All right. Thank you. DeAndre Barlow.
Judge, that's my case. Can you hear me?
I can.
Okay.
We are on here right now for an arraignment in this new case, 21 CR 011. I'm going to go ahead and appoint counsel for Mr. Barlow. Mr. Barlow, you already have counsel in your other pending case, so I cannot recall. Mr. Austin, was it you?
Yes, Your Honor.
Yeah, all right. So Mr. Barlow has been indicted. Of course, we all knew about the potential of this indictment, but it has now been handed down, and it is count 1, strangulation 1st degree, a Class C felony. Count 2, assault 4th degree domestic. That's a Class A misdemeanor. Count 3, PFO 1st degree. Does Mr. Barlow need that indictment read to him and his rights explained, or can you all waive that so we can go ahead and get him scheduled?
We can waive it.
All right, Mr. Barlow, I'm entering a not guilty plea on your behalf and appointing counsel to represent you. Do you all remember when, does anybody remember when his other case is scheduled?
The 25th.
I think in June, the first Tuesday in June.
Okay.
I thought it was the 25th of May.
Or maybe, yeah, it is actually the 25th of May.
Well, I would think that we ought to put this with that and then see where we are when that day gets here.
Okay.
In the meantime, Mr. Austin will take over and with this new case here and be talking to you, I'm sure, about Mr. Barlow about what's going on.
Okay.
I'll send a global offer on both cases with the discovery.
All right. That's all we can do today. Thank you.
Thank you.
Freddie Barlow. All right, Mr. Barlow is here today based upon a bond revocation motion that the Commonwealth filed back on April the 9th. Mr. Gardner, I believe you filed that.
Yes, Judge. Give me 1 second if you don't mind.
That's all right.
Actually, can we call another case and let me pull that up real quick.
Yeah.
I don't have
Mr.
that here in
Barlow,
front of
give me a minute. I'll come right back to you. Craig Jennings.
Good morning, Judge. This is Tim Hendricks. I'm here for Mr. Jennings.
Hello, Mr. Hendricks. Mr. Hendricks, as you are aware, Mr. Jennings is on our docket today for an arraignment on an indictment that was handed down last week charging 3 counts of criminal abuse, first degree, child 12 or under, each of those being a Class C felony. Do you and Mr. Jennings need to have his rights explained or his indictment read to him?
No, sir. We'll waive formal arraignment, enter plea of not guilty, ask for another date to receive discovery and the plea offer if one's forthcoming. And if you're inclined, I've got a couple of questions about the bond, if I may.
Okay, just give me just a second here and let me write all these things down. All right, what questions do you have?
CourtNet shows that it's a $10,000 bond partially secured. Am I correct in assuming that that's 10%?
Yes.
All right, that's, I believe he'll be able to post that. So if we could just get another date, Judge.
I will set a pretrial conference for, let's look at maybe June. How about June the 22nd? That ought to give you all enough time to do what you need to do. 8 weeks.
Judge, that's, I've got a quick family court issue in Barron County at 9, but we'd be able to come down afterwards if that's okay.
You know, before I pull the trigger on that, let me look at something. I have my list of dates over in Metcalfe County that yeah, I better not do that. That's actually our judicial college, so I better stay away from June 22nd. Got to get my hours. Yep. So let's go to July 13th.
And I'll have court elsewhere that morning. Again, could come down late morning, but at 9 o'clock, I'll be in court elsewhere.
Well, let me ask you this. What if I, instead of moving it out, moved it up and we did June the 8th?
I'll be in trial. Oh, June the 8th. Yes, that'll work for me, Judge.
Okay. June the 8th at 9 o'clock.
Thank you, Judge. You have a good morning, if I may be excused.
Yep. Thank you.
Mr. Jennings, this is Ms. Ford from Probation and Parole. If you get out, you need to call me. I have the same number.
Will do.
Thank you.
All right, Mr. Jennings, thank you. Joshua Jesse. Mr. You are Joshua Jesse?
Yes, Your Honor.
All right, can you tell me your address?
1678 Sufferwell Center Road.
All right, can you tell me your birth date?
10/16/1999.
All right, sir. You're here because you have been indicted on charges of burglary in the first degree, a Class B felony, wanton endangerment in the first degree, a Class D felony, assault in the fourth degree, domestic, that's a Class A misdemeanor, criminal mischief second degree, a Class A misdemeanor, terroristic threatening in the third degree, a Class A misdemeanor, violating a protective order, a Class A misdemeanor. Do you have an attorney or do you need to discuss whether you can get one appointed?
I need to discuss getting one appointed.
All right. I believe that,
EPA in district.
yeah, I was gonna say that I thought I had seen that, but I couldn't find it. But yeah, there it is. All right, so I can go ahead and appoint counsel for Mr. Jesse. And Mr. Austin, operating under the assumption that you'll get this one. Do you want to have or waive a formal arraignment?
We can waive it.
All right. Mr. Jesse, I am going to enter on your behalf a plea of not guilty to these charges. We will set this for a pretrial conference. I think it would probably be June the 8th would be a good day for that. At 9 o'clock. Mr. Austin, the bond on his indictment is a bond of $25,000 at 10% with the conditions that he comply with the pending or applicable domestic violence order, and specifically that he not have any contact or communication with the alleged victim or possess any firearms. In the light of the charges and the level of, you know, being a B felony and you know, the nature of the allegations, I'm not entirely sure that I would be that I could be talked into making any modifications to that. I think that that's pretty reasonable under the circumstances.
Is there someplace you would be able to live and stay with, if he did let you out, that you would not be near the alleged victim?
Yep.
Who would that be?
I've got another address of where I'm fixing to move to, and it's 18 miles away from where all this happened.
Um,
I'm getting evicted from a place I was living, so I'm not gonna be living there anyways.
I mean, I would ask that he be put on an ankle monitor and, you know, and have any other requirements that the court would deem necessary to feel more comfortable with him being released.
Who wants to be heard on the Commonwealth?
This is
side?
my case, Judge, and based upon the level of offense and the bond as it said currently, I think that it's appropriate. If the court does make any modifications, as you stated, like that there would be no contact with the victim in this case. There is a domestic violence order in place, but the domestic violence order permits contact, but there can't be any further acts of aggression. Obviously, don't think that that's, I guess, severe enough in this case that it needs to be actually no contact at all if he is released, and would ask that there be a bond condition, not just to follow and comply with the terms of the DVO. Also, obviously, no contact or no possession of any firearms if it is modified. But again, state that feel that it's appropriate in this case.
Okay. Well, I'll take that into consideration. Any bond is already going to have on it no contact, which is, what that's already on there. Because I wasn't sure what the parameters of the protective order were, but
Your Honor, I've got a hearing Thursday to get the protective order dropped.
Well, that ain't gonna change what I'm doing.
I'm just letting you know.
Yeah.
Okay.
So whether or not there's a protective order, if you get out, it's gonna have no contact or communication with the alleged victim in the case. So keep that in mind if you get to that point. Mr. Austin, I'll take that request under advisement. I'm not real sure whether I need to do a little bit of looking into the risk, the pretrial risk assessment is what I'm trying to think of, which I did not do prior to setting that bond originally. So I will take a look at that and see if I can see any accommodations being made. Okay.
Mm-hmm.
All right. In any event, we'll be back on June the 8th at 9 o'clock.
All right.
Okay. Thank you.
Thank you, Your Honor.
All right. Next we have Scott Mars for sentencing. All right, this case is on for final sentencing, and we were on here a couple weeks ago and we moved it over to today because I anticipated that the parties might want to talk about any sentencing issues, since this was one where the Commonwealth had indicated that it believed it had a good case for non-compliance with the terms of the plea. Is this, Mike, is this your case or is this?
No, it's mine.
Yeah. So
yeah, Judge, in this matter, obviously, Mr. Mars was placed on an ankle monitor on furlough. He cut that ankle monitor. There was a new charge related to that, as well as a new charge for bail jumping. Based upon that, in the plea agreement, the Commonwealth's not bound by the recommendation regarding the number of years within the class of felony that it agreed to in the plea agreement. In the trafficking case, the Commonwealth originally recommended 13 years. In that case, at this point, the Commonwealth would make a recommendation of 15 years. In that matter, with the possession case, Commonwealth will keep its recommendation the same, but ask that on the the trafficking case, that he'd be sentenced to 15 years instead of 13 years. That 13 years was obviously towards the low end of a Class B felony by Mr. Mars's behavior when he was granted the furlough. Don't feel that recommendation is appropriate anymore, and ask that you sentence him to 15 years in that case.
All right. Mr. Austin, would you and Mr. Mars wish to be heard?
I believe Mr. Mars wanted to say something. Is that correct, Mr. Mars?
That's incorrect. I'm okay with 15 years.
You're good with 15 years? Okay.
Yeah, let's do it.
All right. I guess we don't have anything to argue. He says that's fair, so.
Well, yeah, he's also, this is just to, I guess, reiterate this. When we talked about, he had a Barron County case. That case is also, the sentencing on that case is also today, because we agreed to do all three of them together. Now, it was a flagrant non-support with another, with a 3-year sentence on it as well. So I don't know that changes anybody's attitude, but I wanted to be sure that everybody understood that we need to get the sentencing on that case as well. That may or may not make anybody want to say anything additional.
Judge, the Commonwealth would stick by its recommendation in that case too.
Okay. All right. This is exactly what I was, and I'm going to tell you, just so you know, but this is exactly what I didn't want to have happen, and you promised me it wasn't going to happen, and it happened anyway. And that's going to screw it up for everybody else that comes after you that asks for it.
Yes, sir. I apologize for my actions.
Well, I mean, that ain't going to
It
do
don't
any
help. But, yeah, it doesn't help, but I'm just saying, you can see on the GPS, I pulled up in this parking lot right here. I couldn't turn myself back in. I couldn't do it. I could not walk in this jail under my own free will. Couldn't do it. I don't know why. There was just a block. I couldn't do it. There's no, all I can do is tell you, I'm sorry. I could not turn myself in. I did, my paperwork, how many years I've done. I couldn't do it. And I apologize for my actions. I throw myself on the mercy of you. I can't do anything but take my time and go on and just do the best I can do.
Well, based upon what the Commonwealth is recommending and based upon what you're saying, I will, when I walked in here, I wasn't sure I was going to go along with anything other than just giving you the maximum I could give you on this trafficking case, to be honest. But, I'm willing to go along with what the Commonwealth is saying at this stage and do 15 years on the 20 CR 26, 3 on the 20 CR 56, and then in the Barron 20 CR 38, be 3 on that. And, those can still be concurrent. I'll still waive your fines and your court costs because you're going to be in jail. It doesn't make any sense to order you to pay that too.
Thank you.
But I didn't think you could do it either, but you talked me into it.
Hey, you know what? I had a slick tongue on paper, boy. I'm telling you.
Yeah.
I don't know what happened to me. I apologize. Like I say, I do apologize to you. My word, no good as far as that goes in that, but I couldn't do it. I didn't know it till it's too late.
All right. Well, that's it.
I appreciate you.
Mona Lisa Pacina.
Miss Burton, and could you please take a look at the chat? Messaged you.
There we go. Thank you. This case is on today for an arraignment in 21 CR 007. Ms. Piscina is charged with 3 counts of criminal abuse in the first degree, child 12 or under. I am going to need to appoint counsel for her. And I believe she had DPA at her district court level, and I believe her co-defendant has Mr. Hendricks. So I don't know that there's any problem here with Mr. Austin. So Mr. Austin, do you and Ms. Piscina wish to have a formal arraignment or waive that formality and proceed with scheduling?
You can waive it.
Okay. All right, so I'm appointing counsel. I'm entering on her behalf a not guilty plea. We will schedule this for a pretrial conference at the same time as the companion case, which is June 8th at 9:00 a.m. And again, this, but like the companion case, this bond is set at 10,000 with a 10% deposit and compliance with any orders of any other court, family court or otherwise. And Mr. Austin, again, with this being 3 Class C felonies, you can try, but I feel like that bond is pretty reasonable.
I don't believe she can make it. I would like, I would like it lowered to something that's she's able to actually make. Whether that requires ankle monitor or anything else to make the court more favorable towards release.
Who's handling this one for the Commonwealth?
It's me, Your Honor.
All right. Do you want to say anything about the bond?
Nothing more than you said before, that there's 3 Class C felonies at 10,000 at 10%, I think is appropriate in this case, and ask that not be modified.
Well, I don't have a problem with taking a look at it again and just reevaluating that. Mr. Austin, I'm not sure that I'm going to have any change of mind on it, but I will keep the file and I'll look at it and I'll see if I can agree to do anything different. In the meantime, we're going to keep that June the 8th pretrial conference date. Okay. Thank you. Yeah. Oh, yeah. Kelsey Brown. Somehow I skipped right over that.
That's my case, Judge. I had filed a motion to revoke her probation. We just need to set a hearing date.
Okay. So all right. So yeah, this is just to set it, right?
Yes, sir. I think
got you.
I had filed it, but she had a warrant out for her.
I got you. Well, I guess we're going to need to do May the 25th. And I'll reappoint counsel.
Your Honor, is there no way you can go and revoke me today?
Do what?
Is there no way you can go and revoke me today?
Well, Ms. Brown, I want you to talk to your attorney first. All right.
Yes, sir.
Thank you. Seth Rigsby.
Judge, that's my case. This is Ken Garrett.
Oh, really? All right. What do we have going on?
Judge, this is a case where he was revoked on his other case. He has a new pending case. And so the only thing we need to do is just, I need to try to get through the discovery with him and then discuss with the Commonwealth and see where we are.
Well, just for the record, when he had Mr. Barry previously, I made my final offer. So Mr. Rigsby is aware of that, and you can talk about that with him further once you get through the discovery. But if he's not going to accept it, we'll just need to set a trial date.
We can do that.
Well, Mr. Garrett, let's do this. Let me, how much time do you want to do to be able to get through, to
Judge,
have?
if you can just give me
everything?
45 days, that'll be more than enough.
All right. That'll put us about June 8th.
That would be fine.
All right.
And Seth, I'll come up there and see you this week.
All right, thank you.
June 8th at 9.
Thank you, Judge.
All right, you're welcome. Buddy Whitlow.
Judge, I believe we have an agreement in that case.
Okay. Do an agreement as in it's ready to go, or an agreement as in you all need
My
to-
understanding was ready to go. Mr. Austin sent me the motion to enter a guilty plea yesterday. I assumed he had just forwarded that or filed that with the court.
I'm sorry. I don't think I did, to be honest with you. Let me scan this again, and I can,
Judge,
who would you like me to send it to? Your
I
Honor?
just emailed it to you, Judge.
Oh, okay.
What I have, but it also only had the front page of the motion to enter a guilty plea. He had taken a picture
Of the
and
back.
sent the back page, and I can forward you that email as well.
I can go ahead and scan it again and send it to you if that's the way you want me to do it.
Well, send it to Chrissy Parker so she can print it and bring it in here to me would be the best.
All right.
And then that way I can show it to, I can show it to Mr. Whitlow and let him see it and verify that he signed it and so forth. Okay?
Okay.
And then Mr. Whitlow, just kind of hang in there till we get all that.
All right, thank you.
Okay. All right, yeah. All right, so let's see, we've got a few other attorneys on here that have, there's Mr. Kimball, I see, Mr. Richardson. I think Mr. Richardson might have you on the age.
By many years.
Yeah. So maybe
I've got everybody on age.
Yeah, I try to be nice to these old folks.
Yeah, I understand. I appreciate it.
Mr. Richardson.
I believe I look younger than Kimball, though. We don't have time to go into that.
Can I vote present but absent?
Yeah. Game.
Is this a fiscal
I've got
court meeting?
set a trial date. The Commonwealth's got a motion to set a trial date in the Tim McCoy case.
Yeah. Are you bringing me something? Look at you. Thank you.
Judge, I don't know if we filed a motion, Bobby. I can't remember if we actually filed a motion or not, but we've tried to resolve this case. We haven't. We've had trial dates set various different times, and this past time got continued because of the COVID regulations, so we do need a trial date.
Yeah, I believe we just had the last trial was a COVID casualty, so it was set almost exactly a year ago, wasn't it?
I think you're right.
All right.
Judge, I don't know when you're looking, but he's scheduled for surgery in July of this year.
Yeah, I was. I've got a little bit of time at the end of, well, anything that I schedule is going to be, I'm bumping some, I'll be bumping some kind of civil trial because I've got them scheduled all the way out through May of next year. But I mean, I think they all probably know that it could happen. I could probably do, no, that won't work. That won't work.
Set it in May next year.
I mean, I could do that if that didn't crawl all over anybody, but
that doesn't
all
bother me.
That's about all I can
No, it
do.
doesn't bother Bobby. I mean,
yeah, sure.
This case has been pending.
You want it before then, John?
Well, this case has been pending so long. I mean, that's the only issue.
I could do the 30th of November. We had 2 days the last time. So, I mean, I could do the 30th of November and the 1st of December.
Your Honor, if I'm not mistaken, I think I've got is that Knatzer trial set right after that?
I thought we set a trial for those dates, Judge, last week, and I can't remember.
Well, can you look it up and see? First week.
I know that Knatzer's right there, the end of November, beginning of December.
I'm not going to tell you that it's very possible that we did that and somehow it didn't get on my calendar. That has been known to happen, although it's not very often.
I have Knatzer down November 30th to December 3rd.
Well, there you go.
I guess that means we'll be in May then.
Yeah, I mean, my other problem is I've got, well, you've heard it all before, so I don't need to keep telling you. But
I've heard it too, and I know it's a big problem, and I can't help it though.
I've got a 3-week trial in January and a 3-week trial in February. I suppose if you all wanted to, I could try to do February maybe like the 24th and 25th. That'd be a Thursday and a Friday.
Your Honor, intend not to be in the Commonwealth of Kentucky for the month of February.
Oh, okay. Take me with you. March is out, April's out. So yeah, here we are. I just set a trial on May the 17th, but they thought it would only be 1 day. So I could do the 18th and 19th or the 19th and 20th.
Well, I told you yesterday, I don't buy green apples.
Yeah.
I mean, green bananas, so whatever day you said will have to work for me.
Well, what do you want to do, the 18th and 19th?
What days of the week are those?
Wednesday and Thursday.
That's fine to me.
That's fine with the Commonwealth as well.
I'm gonna have to go through and look and see if I Yeah. So I remember to write that down. That got by us. All right, hold on a sec, everybody. 17.
Who did you tell me to send it to again, Your Honor?
Chrissy Parker.
Chrissy Parker, okay.
I've got everything but the second page of your motion. She's brought, or yeah, she brought the rest of it in. All right, so this will be, let's do a pretrial on it, if you all don't care, in like January, February, something like that, just to be sure that everybody.
fine.
No, you said you won't be here in February, right?
Right,
January 25th.
All right.
All right.
Thank you, Judge.
Okay, thank you.
We'll be leaving.
Thank you, Judge.
I say May 18th. Oh, yeah, okay, yeah, I get you. All right. Let's get, looks like we got Mr. Barlow back up here.
Yes, sir.
Judge, on Mr. Barlow, as far as the bond motion, the Commonwealth would offer a sanction for time served in that. I think he was arrested, the early part of this month on that. And Mr. Austin has contacted me about a possible resolution of this case. I need a little bit more time to think about that. It's generally, we not agreed to unsupervised probation. So I just need to consider that and then talk with Mr. Austin about that.
Okay, so we'll need to give Mr. Barlow a pretrial date. How long would you like? I mean, can we do that May the 25th, which is a month, or do you want to go further than that?
No, that's fine.
All right, so Mr. Barlow, instead of, thank you, instead of revoking your bond based upon your new charges, the Commonwealth has agreed to just a sanction, which be accompanied by a reminder that you're on bond and you need to be sure that you are compliant with your bond conditions. And we're going to set this for a pretrial conference on May 25th at 9 o'clock. You'll need to get in touch with your attorney when you get out so that you all can discuss where we're going from here, okay?
Okay.
Do you have any questions?
No, sir.
All right. You'll be getting out today then, so just give him a call, okay?
Yes, sir. Thank you, Judge.
All right, I got Mr. Whitlow's stuff now if he's ready.
Buddy. Just a second, Judge.
Okay. All right, Mr. Whitlow, can you raise your right hand for me? Do you swear or affirm that you will tell me the truth, so help you God?
Yes, sir.
All right, thank you. Mr. Whitlow, and your attorney had sent me the following documents. This is a motion to enter a guilty plea. Can you see that?
Yes, sir.
All right. It has a signature page on it. Is that your signature?
Yes.
Very good, thank you. There's also a motion, or I'm sorry, a offer from the Commonwealth. You see that?
Yes.
And there's a signature page.
Yes.
On that one, is that your signature?
Yes.
Did you read over both of these things before you signed them?
Yes.
All right. Did you have time to discuss them with your attorney?
Yes.
All right. Mr. Whitlow, do you understand that any plea of guilty has to be your decision? In other words, nobody's making you plead guilty. Do you understand that? Did you say yes?
Yes, sir.
All right. Do you also understand that if you plead guilty, you waive the right not to incriminate yourself, the right to have a jury trial where the Commonwealth has the burden to prove guilt beyond a reasonable doubt, the right to confront and cross-examine witnesses, the right to put evidence on in your defense, and the right to appeal?
Yes.
All right. Do you understand? Well, let me back up and ask this question. Do you feel like your judgment is impaired for any reason today?
No, sir.
All right. The Commonwealth has made the following recommendations in your case. Your indictment had count 1, receiving stolen property, $10,000 or more. That is a Class C felony. The Commonwealth will move to dismiss that charge. Count 2, possession of a controlled substance, 1st degree. The Commonwealth will recommend on a guilty plea a sentence of 2 years. Count 3, persistent felony offender in the 1st degree. The Commonwealth will move to dismiss that. Therefore, the recommendation will be a 2-year sentence. The Commonwealth would also agree to supervised probation of that sentence for a period of 2 years on the condition that you get an assessment through probation and parole and follow any treatment recommendations as part of your probation. The sentence in this case would be consecutive to any time that you would get in, or that you have in Cumberland County. Do you understand that?
Yes, sir.
All right. Other than what I just told you, has anybody promised you anything to get you to plead guilty?
No, sir.
Or has anybody threatened you to try to make you plead guilty?
No. No, sir.
Mr. Whitlow, are you pleading guilty voluntarily after consulting with your attorney?
Yes.
All right, sir. Do you acknowledge that on April 25th, 2020 in Metcalfe County, you knowingly and unlawfully possessed methamphetamine?
Yes, sir.
All right. I'm going to accept your plea of guilty today as having been entered freely, knowingly, intelligently, and voluntarily with counsel. Mr. Whitlow, are you still, your Cumberland County case is still pending?
Yeah, I'm still fighting it.
When do you go to court on that next?
I was supposed to went to court last week, but they come at me with an offer and they set a trial date. I'm not for sure when. It's a ways off.
I'm showing May 27th.
All right. Well, here's my question, I guess, is whether we wanted to go ahead and just sentence Mr. Whitlow today, or did he need to wait and have a sentencing at a later date for some reason?
I think he would be happy just to do sentencing today.
Yes.
You want to do that?
Yes.
All right. Then I can go ahead and impose this sentence of 2 years. I will grant your request to probate that sentence for 2 years under the conditions that we discussed. I just need Officer Ford to know that I believe you've still got this, you still hadn't made bond in the Cumberland County case, so you're not gonna, even though we're gonna send something to the jail telling them that we're not holding you, if we hadn't already done that, you are not going to probably be getting out today till you get something squared away in Cumberland County.
Right.
Okay?
Okay. Thank you.
All right.
we gotta be here. If June.
I believe that has me squared away with the jail.
That's all I've got, Judge.
I'll see you this afternoon, Miss Bonnie. All right. We'll get Mr. Kimball up next. I don't want him to think I misled him. All right. Vincent.
There he is.
Thank you. All right. So I believe you're I guess you're here on the Vincent matter, right?
I am, Your Honor. I just got notice on this yesterday, and I've talked to Mr. Vincent. I would really like to probably set it out a short period of time if we could, so I can talk to the Commonwealth some more about it, since I haven't talked to them. My understanding, though, is why he did not show up for his testing was that he was at the hospital. So I think if I can talk to the Commonwealth and show them what we've got on that, that may convince them potentially. He was taken to the hospital by ambulance.
Yeah, and I do see that you have filed that. Without going into the details of it, I would just make the observation that you know, I don't think that any of that information had gotten provided to Miss Atkins, and that's why she filed what she filed. But again, it's sometimes communication is the whole deal. You know,
Exactly.
Another issue that we've got is, and I agree with you that, I mean, we need to set it for a hearing anyway, but Officer Ford might want to jump on here and just explain some of the issues that she's been having, because she's conferenced with me on those since it's a probation case. And you know, I'm trying to give Mr. Vincent as wide a berth as I can with his health issues, but I'm gonna let her tell you, but she's gonna have some issues with compliance. We're not putting this on as proof. I just want this, I want Mr. Kimball to hear this from you so he can address this with his client before we come back.
And I think is on with us, Your Honor. I checked with him earlier. I think he is on with us as well.
Well, I have a name, but I don't have a camera, so I don't know if he's listening or not. Mr. Vincent, are you hearing me, and can you turn the camera
Yes.
on?
Yes, I'm trying to, sir.
He is on with us.
Okay. All right. Officer Ford, just give Mr. Kimball a brief rundown of what's happening on your end.
So originally, when he was probated in February, he tested positive for methamphetamine, and he admitted to that prior to being placed on probation. He was assessed by our clinician and was referred to treatment for that back in February. As of today, he still has not complied with the substance abuse treatment. However, he reported that his substance abuse assessment for that drug screen was set for the day that he went to the hospital, which was April the 20th. I talked to him yesterday and he still had not made an appointment. I talked to the people there and they said each time you miss an appointment, it's 2 weeks out. So he's looking into May. So we've been using meth since February. He also was positive again when he finally came in on the 22nd of April, and that was confirmed through a lab test. So we have 2 positives and no substance abuse being addressed at this time.
And I, like I mentioned, I'm not, you know, that wasn't testimony, so I'm not taking that as proof of anything to be. I mean, if we end up having to have a hearing, she'll get on the stand and testify, and we'll go from there. But I just wanted to get that out there so that you and your client could discuss that in preparation for trying to get back to deal with this after you've had the chance to talk to the Commonwealth attorney as well. Can you do May the 11th?
Yes, sir.
Mr. Kimball, can you do May the 11th?
I can, but based on what was just given, I would like to get him in for his substance abuse assessment before our hearing, I think that would be beneficial. And she said it's usually a couple of weeks out to do that.
Your Honor, I've talked to him down at Wilson Counseling. I've got to get back online with him at 2 o'clock on May the 4th, but I told them that I had a appointment with my probation officer at 1 o'clock. So they just tried to call me a while ago.
Yeah, I think he's already had the
Your
assessment.
Honor, I will just
What
state
he
on
needs
the record.
to do is make his first appointment and get in and start talking to his counselor is what I think the deal is.
No, he never did the assessment. He missed it last week on the 20th.
No, but he
Yeah,
got assessed in February.
Well, he got assessed for our clinician and then she referred him to treatment, but he's not doing the treatment. He keeps missing the assessment for the treatment.
I was at the hospital that day.
Yeah.
Okay.
And Your Honor, the no-shows for U-turn were on the 15th, I think, and the 16th and the 14th and the 15th. And that note, Mr. Kimball, is for the 20th at the hospital. So it's not on the days that he was called in to test for U-turn.
Yeah, I think the thing that Mr. Kimball has showed us was the day that Officer Ford had called him to come in instead of.
Okay.
I'm not sure, but I think that she called it. When Julie sent that in to me, I called Officer Ford and I asked her to get him in and she attempted to, and then I think that's what happened. But I don't mind. I was just trying to, I don't mind when we do it. I have a similar concern that Officer Ford has, which is just that, we've had a positive test and then another one, and we haven't gotten into any treatment and we've been working on it for 3 months. So I didn't want to drag it out too much further. That being said, I'm not married to that May the 11th date. If we can put it out a little bit further, I just want him to start getting in on, doing what he's supposed to be doing.
And we'll have a conversation about that, Judge. What is your next date after?
May 25th.
Okay. At 9.
Yes, sir.
Can we make it a little later in the morning? I've got a couple of courts here that morning, and you'll probably be doing court all morning, won't you?
Yeah, we usually do. We usually have at least a couple hours.
If I could bounce it on out till maybe 11, I've got a 8:30 and a 10:30 here that morning. But how long you'll be having hearings, I'll jump on as soon as I get done with those. So if that works.
Yeah, I can do that. We'll try to do that. And of course, you're going to be talking to the Commonwealth anyway, and maybe you all can have a discussion about.
We'll try
other things, but we need to get the ball moving towards compliance. You know what I mean?
Yes, sir.
And Your Honor, in that vein, I would request that, if he doesn't show up for a test with Charity or if he's called in with Julie as part of his home incarceration, that a bench warrant be issued.
Yeah, I want him to be getting his test. That is still an obligation, and I still want him to be compliant with that. I don't want to wait till May 25th and then start talking about being compliant. That's why I wanted to get in here as quickly as we could if he's not going to do it.
Robert, are you hearing this?
Yes, sir.
Okay.
If they call you and tell you to come in, you need to come in. Okay.
Okay. I hear you, Judge. Thank you.
Got it down 25th, but it'll probably be up near 11 when I get on that.
Okay. All right. Thank you.
Thank you, Judge.
All right. Let's see, Jackson Blair.
Yes, sir.
I'm just going alphabetical at this stage.
Your Honor, I think we've got an agreement in this matter. In lieu of avoiding diversion, I think we agree that stipulate to the violation, void the diversion, actually, and agree to probation, supervised, condition that he's been assessed by the SSC with the condition that he follow those recommendations.
Yeah, we can do that. if that's what Mr. Blair is agreeing to do, all I need to do, he's already on, he's already been supervised with probation and parole. So that's just a change of status. It won't require a whole bunch of extra paperwork. This Officer Ford can just address.
Right, and he's already a convicted felon as well out of Greene County.
Yeah, and Officer Ford can address with him where and when she needs to see him next.
Can you come to the office next Wednesday on the 5th?
Yes, ma'am. Yes, ma'am. Sure can.
In the meantime, call me tomorrow.
All right.
So you have something in the works to get your restitution paid?
Yes, sir, I do.
All right. All right. Remember, that is an essential component to all this. Okay?
Yes, sir.
Does that make sense?
Yes, it sure does.
What'd you say?
What's the length of probation on this? Is it 2 or 3 years until restitution is paid in full, or?
Yeah, hold on. Let me see. How long has he been on diversion?
He's been on, let's see.
About a year and a half? Well, about 2 years.
He was probated February the 13th, 2019, and then he didn't get out of jail until like December because he was serving for that Greene County case.
I got you. So a year and a half.
Yeah.
Yeah. I would do 2 years or until restitution is paid in full.
Okay.
Okay.
All right.
Be sure to report as directed. All right. Thank you.
Yes, sir. Thank you.
Mr. Bell, who are you on for? Oh, Mr. Wilson?
All right, Donna, we'll holler at y'all. Yeah, Bradley Wilson, Your Honor, Justin Harper. Bradley Wilson is here, and both of them's here, Judge.
Judge, on Bradley Wilson, I'd filed a motion to revoke Mr. Wilson's probation.
All right.
Your Honor, I think we just want to get a date today.
That's true, Judge, but I was confused as to what happened. I know that he was in jail and then he was released, and I didn't know if he was being released because he was going to a treatment facility or had been recommended. I didn't know what his current status was.
No, yeah, I can address that. When he came in and met with Officer Ford, he had a positive test. I don't recall exactly what it was positive for, but I think she could tell us. I think there was meth and marijuana maybe. And I told her that she talked with him, and at that point I said, I want you to lodge him until he can get an assessment. And then if the assessment is for outpatient treatment, then we'll release him and have him start doing the outpatient treatment. And that is what the assessment was for. So she released him. She went up to the jail, and after he got assessed, and released him, and I told him to start doing his outpatient treatment.
I'd like to set a hearing. One of the issues that came up was he admitted that up to a month prior he had been using, and one of the reasons why I agreed to do home incarceration because I thought he was doing what he was supposed to. I don't think that was the case. I'd like to have a hearing.
Yeah, that's fine. Yeah. When do you want to do it?
The next revocation date's fine.
We can probably do, it'd probably be best to try to do it May 11th because that'll be the lightest day we're going to have for the next millennium.
That's fine.
All right, Mr. Bell, let's do May 11th.
Yes, sir, Your Honor.
Nine o'clock.
Yes, sir. The other case, I got Justin Harper for arraignment, Judge.
That's my case, Judge.
Okay. Bell, this indictment is driving under the influence, fourth, or Fourth offense aggravator, operating DUI suspended. Second offense and criminal mischief, third degree. Right.
Please, the court, we'd waive formal reading the indictment. Acknowledge that Mr. Harper's individual name within that indictment, enter plea of not guilty, ask to reserve the right to file any and all motions pertaining to his case. And Mr. Harper is present here in my office.
All right. Let's see. When do you want to set this for a pretrial?
Whatever pleases the court, Your Honor. We done some yesterday, I believe, around the, we done some for the 24th. We done some for the 10th. We done some for June, but I can't see where I wrote that down, Judge, so.
Well, those are all Barron County dates, though.
Oh, yeah, I'm sorry. That's right. I got lost as a goose in tall grass for a second.
Well, we'll try to lead you back to the mode part, you know, to the pasture.
Yes, sir.
Let's look at June the 8th. That'll be at 9.
That's fine, Your Honor. And the only other circumstance, Your Honor, I was hoping to ask the court to make an oral motion to remove Mr. Harper's ankle monitor. I think he's done about how much time in jail? He's done 130 days in jail, incarcerated, and now he's had the ankle monitor on for a little over a month, and he's not had any issues on either side of the coin.
What kind of ankle monitor is it? Is it a scram bracelet or is this just for house arrest?
Well, let me jump in here and tell you, here's what happened. He was on that out of the district court. When he got indicted, I'm gonna be honest, I didn't know that he was on this. He was on that because we just had a revocation hearing not too awful long ago, and his probation had got revoked. And I honestly didn't know that he had gotten back out of jail that fast, but he had. So I just did a cash bond because I thought he was still in jail, but I did not put on the bond that his bond had a condition that he had to get an ankle monitor. So, but he got out over the weekend because he posted bond over the weekend, and there wasn't any way for anybody to look up and see what was going on with his, that he had posted the bond. So his bond did not have ankle monitor on it as a condition after he got indicted. So I'll let Julie know that that's the case. And I mean, I can't impose it. I can't turn around and put it on there when I didn't put it on there originally and he hadn't done anything since then to get it. I just said it 5 days ago and he hadn't gotten in any trouble since then. So I can't add a not punitive, but a condition that's harder to him. You know what I mean? That's harder on him when he hasn't done anything to deserve it. I mean, it probably should have been on there originally, and that's my mistake if it wasn't, but there we are. Okay.
Yes, sir.
Because Julie actually called me about it, and I told her that that I didn't think that I thought that he still had to have the ankle monitor on because Judge Pendleton had ordered him to have it on there. And I didn't have any idea that he had actually gotten picked up and served with the warrant and all that because there wasn't any record of it. And it was like a Friday, or it was like on Sunday. So, I couldn't look anything up. Okay. So, anyway, that is what it is. And I will let Julie know that his bond condition in this indictment does not have the ankle monitor on.
Thank you, Your Honor. Y'all have a good day.
All right. But now listen, it does, it should, and I'm not looking at the bond, but he does need to understand that he can't drive without a valid license and all that other, because that's part of complying with the law, which is always part of your bond, you know. Okay,
Yes, sir.
all right.
Thank you.
Laura Burton,
Yes, sir.
Judge, on Ms. Burton, it's been a while since we've seen her. Robert and I were talking earlier about her case, and I had made an offer and don't think she was willing to accept it. But since this is the first time we've seen her in months, I'd like to continue this to a date later in May when we're back in person, or June if that works, so we can continue to talk about it. I've offered pretrial diversion, and that's the best it's going to get. So I think it's worth putting it on another day to try to work it out.
I'm not going to accept it.
hey, turn your camera on.
How do I do that?
Think it's covered. There we go.
Miss Burton, we're
Yes.
I'm rescheduling your case for May the 25th at 9 o'clock, and I expect you to be there, okay?
Okay.
All right. I expect you to talk to your
Thank you.
lawyer between now and then too, okay?
I have tried.
I'm not talking about what's happened up to now. I'm saying I expect you to talk to him between now and then, okay?
Yes, sir.
All right.
Is that going to be in person or still by Zoom?
I think Mr. Richardson is asking that we set it for in person, which I'm okay with.
All right.
Yeah.
All right. All right. Thank you.
Thank you.
Yes. Let's see, Alicia England.
Here, sir.
All right, thank you.
Judge, on Miss England's case, I've talked to the clerk's office, and she's made one payment since December. That was $600.
I have, yes, sir.
And then today she tried to give a check for $1,200, but then asked the clerk's office to backdate it to Friday, and couldn't give a guarantee as to whether or not the money would be in there or not. But anyway, even if she had paid the $1,200, I don't think I think the court had her on a payment schedule to make up to 10 payments, I believe, at a certain date in the spring, and then it was continued again until today for her to make further payments. But again, the only payment she's made is $600 since December.
He is correct, Your Honor. I filed for unemployment in March of 2019 on the 21st, and there were 9 months that I did not work nor receive it. Not sure what happened, but I am doing the best that I can. And the funds were deposited. I contacted my corporate office. The funds were deposited and the check is good. So my CEO did that as a favor to me this morning. So once I pay the $1,200, how much farther am I behind?
So you can get the 1,200 up there and get that taken care of then, is what you're saying.
Today. Yes, sir.
Yeah.
Absolutely today. But
Right.
with the 9 months of no unemployment, all I received was an automated call twice a week for like 6 months.
No,
that they would
I'm
contact me. Yeah.
I'm not hollering at you about that. I'm just trying to
I
make sure I
know.
understand what you're saying. So,
Yeah.
so I think you'd be $200 behind from where you
Yes,
were
sir.
supposed to be if you paid
Yes,
that.
sir. And I'm doing my best to get caught up, I promise.
Well, Judge, I'm looking at the file. Where are we at so far as when you say she's almost caught up? How?
No, I'm just talking about since the last time that I saw her. I think she definitely got behind, before, but when I saw her in, I'm trying to find out when it was, October of 2019, And then we started putting her on these regular payments. She was current the first 2 times. Then we came back. It was right after the pandemic had started. She had lost her job or had been laid off or whatever happened. So I stretched her out to whatever that other date was. I mean, I can't find it all. But at the end of the day, the last time that we rescheduled it, she was supposed to have $2,000 paid between those 2 court dates. And if she gets the 1,200 up there, she'll be $200 behind on that, just
Yes,
since the
sir.
last court date. So,
Can we
that's,
make it? I'm sorry, Joe, to interrupt you.
no, go ahead.
And she's saying it's available Friday. Can we have her make that 1,200 due by Tuesday?
I think she's saying it's available right now. I think
It's
she's saying
available yes, sir.
she called her work and they said it was available right now. So she's going to go up there, be able to go up there today and pay it.
All right.
Yeah. And so what I think we can do is, take a look at it down the road a little bit and, just try to, and I understand what you're telling me. It is a lot easier, if you can pay every month or something like that so that everybody can keep up with it a lot easier.
I know, but for me, it's not, Your Honor. Especially, I feel like I'm trying to play catch up every which way I'm turning. And I could have had it prior, but I had to get taxes and tags on all my vehicles and property, and that comes like clockwork too.
Oh, I understand. I'm just telling you that.
Yes, sir.
We avoid a whole lot of these issues if you were able to do that.
I know.
Okay.
Yes, sir.
Let's look at we went over to the last Tuesday in July.
Mhm.
That would be 3 months, and with the extra payment that 4 payments.
Mhm.
So let's give that a shot, and then
Okay.
I think we're better off if we look at it a little bit more frequently. And of course, we couldn't do anything about the pandemic, but that affected
No.
everybody, including you. So,
Yes, it did.
everybody's just trying their best. But
Yes, we are.
we'll do July the 27th. And I expect that we'll be able to be in person at that time.
Okay, sounds good.
All right. So we'll see you on that date. And like I said, it'll be 4 payments of 200.
Yes, sir. Sounds
All
good.
right.
Thank
Thank you.
you. Bye-bye. Am I dismissed now?
Yes, thank you.
Thank you, Your Honor.
Janice Fields. Ms. Fields, can you unmute your mic there?
Yes.
All right.
Your Honor, the note I have is, it states that their payments are caught up.
Janice, did you come in and pay earlier this month? Is that what?
Yes. I paid the 300 and I think it was 300 and something.
It was
Yeah,
380.
look, 380. Yeah. All right. So I guess what we want to do, Mr. Gardner, is probably review it in a little while to, 6 months or something like that to see, make sure that we're continuing to pay these.
Yes, Judge.
All right. 1, 2, 3, 4, 5, 6. Let's go to October. That'd be October 26th. Would probably be 6 months from now. So that's going to be 6 payments. You with me, Ms. Fields?
Yes.
Preferably, you would pay those each month as they accrue rather than wait all at one time.
Yes, sir.
Do you have any questions?
No, sir.
All right. Anything, Officer Ford, that you need to tell her?
No, sir.
All right. We'll see you then.
All right. Thank you.
Thank you. Estella Geis.
Yes, sir, I'm here.
There you go. Let's see. Mr. Barry.
Yes,
I guess
Judge.
we're basically on here just for a pretrial conference, isn't it?
We are.
Kind of just need to get oriented, I guess.
This case has been set for trial back last October or December. I can't remember which it was right now. Of course, it got bumped because of the pandemic. I think that's all we need to do now is pick a new trial date, Judge. I really, Ms. Geis and I have met a few times. I don't think we're gonna reach a resolution outside of trial, so.
Okay. All right, hold on a minute. All right, how many days do you think, Greg?
I would say one, but two may be safer.
I agree with Greg. In normal circumstances, this would be a one-day trial.
All right. May 26th and May 27th, 2022, and we'll do a pretrial in April.
My calendar doesn't go that far, Judge.
Yeah, well, I mean, I figured this is what was going to happen, but we've done nothing for 13 months, and then in 2 weeks, everybody wants a trial, so I'm just going to have to do the best I can.
Yeah.
May.
Don't confuse my comment with complaining.
No. I wasn't confusing that at all. I'm frustrated at the situation, not at anybody. It's nobody's fault. April 12th, we'll do a pretrial on April 12th.
Okay.
And trial 26 and 27 of May.
All right. Estelle, stay on the call after we're finished here. So I need to send you a message.
Absolutely.
All right. Thank you.
Okay.
Thank you, Your Honor.
Mr. Gardner, on the Glass case, you all sent me an agreed order with to reschedule the pretrial, but the date was blank, and so we checked when Mr. Richardson was on here earlier, and Crystal called him, and he asked June 8th to be put in that. It was June 8th, wasn't it?
Yeah, that's fine. I signed it as I was heading out the door yesterday, and so I didn't realize that the date was blank, but.
Oh, yeah. No, I wasn't criticizing. I was just wanting you to know what date I put in there.
And that,
you probably have the file there and you were, wanting to write it down.
Right. I think that date's good because I think he's got a review on that DUI case sometime in May, if I'm not mistaken.
Yes, sir. John Eric Lynn is in Blackburn Correctional, and they're not going to get on. I mean, you email them and call them, and they don't ever answer you, and we're not going to be able to get on.
Yeah, I've been having that trouble just trying to go talk to him.
Yeah.
And I don't think they're going to let me in person either. So,
I mean, I guess those guys can get moved without warning. So I guess I'll put it out maybe to the end of June or to the end of June ain't gonna work. The beginning of July, and we'll check up and see if he's still there, and maybe he'll be in another facility, and maybe he won't. July 13th. Miss Neal?
Yes.
I believe this is probably an arraignment, right?
Yes.
Because it's been out for a little while, but we hadn't been meeting, so. Okay, so do you have an attorney?
I don't.
Do you need to have one appointed?
Yes.
All right. So we will do that. Your charges are possession of controlled substance, first degree, first offense, fourth degree assault, third degree assault, resisting arrest, possession, third degree, drug paraphernalia. Mr. Austin, let's can we just go ahead and move into scheduling this?
Sure.
So Miss Neal, I will appoint counsel for you, and you and he can talk about your charges, and then whenever he gets your discovery, you all need to get together on that. I'll put you on for a pretrial conference June the 8th at 9:00 a.m. Okay.
Okay, thank you, Your Honor.
And do you all know how to get in touch with one another?
I don't.
She could give us her number, and I'll pull up our number so I can give her ours. Our number is 833-385-6055.
Okay, do you need my number now?
Please.
Okay, it's 270-576-2103.
All right. Y'all got it? Thank you.
Got it. Thank you.
Timothy Pittman.
I sent Mr. Pittman a chat. I don't think he has seen it. I didn't get a response from him.
He's on.
Good morning, sir.
Good morning, Mr. Pittman. Did you get a message from your attorney there?
Yes, I see it now.
All right. Do I need to give you a minute to respond to him or whatever? Move on to somebody else?
Yes, please.
All right. Got Dennis Pulliam on here. What's that about, I think? Restitution?
I have a note here, Judge, that he hasn't made a payment since February.
Yeah, it looks like February 22nd.
You want me to tell him something? I'll supervise him on parole for this case.
Yeah, give me just a minute to see where we are on. He was supposed to pay $240. It looks like he. No. At this point, he's supposed to have paid $360 since his last court date. And it looks like he has paid some of it, but not all of it.
Pull over.
Yeah,
Let's go through it, right? He's going through it.
Charity, the best, or Officer Ford, the best I can tell you is looks like he's paid maybe less than half of what he should have paid since the last time we saw him.
How much do you all have him down paying? I think the problem is maybe the parole board only orders him to pay $25.
Yeah, but last time we were in court, I told him that I was going to order him to pay $40.
Okay, I'll call him and tell him.
But I mean, I explicitly told him that.
Okay, so how much is he behind? I'll tell him to come pay it.
Well, he's behind a ton, but
Yes,
since the last court date, which was 9 months ago, he should have paid $360, and I think he's paid 120 or 140. 140.
Okay, I'll tell him. He's been laid off for a little bit, but I'll call him and tell him here in a minute.
Where's he working?
He went back to work at this place in Russell Springs. Let me see. It's called Highview LLC in Jamestown.
What do they do there?
I'm not really for sure. Something outside, because a lot of time when it rains, he doesn't get to work.
All right, so he owes, what is it, 220? He'll owe $340 by July the 27th. So when I see him on July 27th.
Okay, I'll tell him.
From now to then, he needs to pay that much.
I wish he'd pay it all because he'd be off parole if he did.
Well, wish in one hand. At the rate he's going, I'm not sure he's ever going. He owes $2,174.83. Okay.
Okay, I'm talking to him now.
All right. Joshua Russell. Yeah, let's see. This is a motion, what's Commonwealth's motion to revoke probation, is that right?
Correct, Judge.
Okay. Let's look at.
Good morning, Your Honor.
Good morning. All right, so you need to set this. I need to appoint counsel for him, right? And then set this for a hearing. Is that what we're asking?
Yes, Judge.
Yeah. I think and this, I'm not being critical here. I'm just trying to figure out, make sure we're all talking about the same thing. In your motion, it says that he received a new felony arrest, but the arrest in Logan County looks like it was assault 4th degree. So is that the arrest that you're referring to? Or
It is
there
a
another arrest?
no, Judge, if it says felony, that's a typo. It's the assault 4th degree charge.
Well, and I wasn't sure whether it might have been like an assault 4th, 3rd offense or something, but it has a M case number. It's 21M 138. So not that they always get that part right, but
Right.
I just didn't want there to be any confusion when we came back about what you all were going to be attempting to put evidence on about.
I understand, Judge.
Okay. I guess we'll put it on May 25th. Let Mr. Austin and Mr. Russell discuss how they're going to talk to each other.
Could you give us your phone number?
I can right now.
Yes.
615-561-3125. And can I give you an email?
Sure.
It'll be Selena, SELENA, and it'll be Koontz, KOONTZ. 2000 at gmail.com.
And our phone number is 833.
Give me 1 second.
All right.
Okay, go ahead.
Our phone number is 833-385-6055.
All right, let me read it back off to you. 833-385-6055.
That's correct.
Okay, thank you.
All right. See you in May.
What time?
9.
Yes, sir. Be here. Have a good day.
Thank you. All right, let's see. Mr. Pittman, he's all we got left.
Mr. Gardner, I just noticed on the form you, did I ever send you that form?
I'm sorry, Robert, I don't know what you're talking about.
For Tim, I have an offer from you on this case. I had it.
Yes.
Yeah, I sent you that form back.
I don't think you sent me anything back, no.
Oh, I'm sorry. Well, he signed it, but I noticed on here, and apparently I wasn't paying very much attention to it. Under account 2, it said 3 years, but under total time, it said 2 years. 2 years is what I told him. I wanted to make sure it was actually supposed to be 2 years because,
yeah, I'm fine with 2 years, yes.
All right, good. I wanted to make sure before.
A typo if that was.
Yeah, all right. I just wanted to make sure you didn't sign this one, so I'll send it directly to you. But
well, I guess, Judge, do you want to do this today or do you want to do a different day or?
I don't care. I mean, Tim, you're still in, are you still in a treatment facility?
I'm actually currently in IOP, which is intensive outpatient. I graduated the treatment facility already. I'm just doing the aftercare program that they have, and I'm also working with them as well.
Are you living in a, like a halfway or transitional, I don't know what exactly phrase you all are going to use.
Yes,
but
sir. Yes, sir. Sober living house.
Sober living. All right. Yeah. I mean, I don't care when we do it. We can do it right now if you want to, or we can do it the next time we meet. It's just going to be a month.
Well, I'm just saying, if you want to do it right now, if Robert can just send it to Chrissy and then you can sign my name.
Yeah,
So we
we'll
don't have to
send
go
it.
through that process.
All right.
He can send it to Chrissy. That'd be super.
Uh,
Mr. Pippen, hold
yes, sir.
on. Yeah, go ahead. What you got?
I was gonna say, if we do it today, I'm currently residing in Pulaski County, Somerset. So that's where I would need to be taking care of business.
Sure.
Okay.
Officer Ford, you want to talk about that? Well, listen, I'm gonna run in there and get the papers and I'll come right back.